Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light in the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Morant. 5 and 2? 2 minutes? Sorry, I'm a little hard of hearing today. 4 and 2 and 3. Branch Banking v. Coot.
Michael Carlson for Appellate, Juliet Coot, 5 and 2 yards. He began for Branch.
5 and 2 and 4. S. Amy v. Sanjay is submitted. Kent v. Bernstein.
Afternoon, Your Honor. Matthew Coleman for the appellants, 5 and 2. Good afternoon, Your Honor. John Arclides for respondents.
You don't have a cross appeal, do you? You don't have a cross appeal, right? No. Okay, 5 and 2 and 5. Ravello v. RXR 32 Old Slip. 4 and 1. 4 and 1. Oh no, excuse me. Yeah, 4 and 1, 4 and 1, and you said you wanted 1 minute? 1 minute. You got it.
Sorry, Your Honor, I don't have a cross appeal. You're okay?
Okay, so I'll just give you 4 then. Thank you, counsel. People v. Arthur Hernandez.
Respond in 5 minutes, please, Your Honor.
Give you 4 and 1 and 4. Gomez v. New York City Department of Buildings. Very well, thank you, counsel. Leven v. Salvini. Five and 2 and 5. V. O'Neill. Submitted. New Empire Builder v. Onboard Hospitality.
For the respondent, motion to grant 5 minutes.
5 and 2 and 5. People v. Pichardo.
Respond in 4 minutes, please, Your Honor.
4 and 1 and 4. Louie v. New York City Department of Education. Is anyone here for the Department of Education? Ms. Jean-Louis, it's customary in that situation you can either go on what you said in your papers, or if you wish to address the court, we usually give the person 3 minutes if there's no opponent present. Okay, we'll give you 3 minutes. That's all right. Danielle BJT, Megan and Company. 5 and 2 and 4. Silverman v. Pretto Manger.
Good afternoon, Your Honor. 4 and 2. Respondent, request 4.
4 and 2 and 4. Gordon v. 476 Broadway Realty. Five and 2 and 4. People v. Phillips. Five and 2 and 5. Drew v. U-Haul International is submitted. First case up is People v. Morant. Please.
Good afternoon, and may it please the court. I'm G. Henry with the Legal Aid Society on behalf of appellant Mr. Peterson Morant.
Counsel, you may want to put the microphone closer.
Is that better, Your Honor? After a lifetime of living with mental illness without a single incident, Mr. Morant reached his limit after going through a year of the pandemic, homeless, unemployed, sleeping in subway cars, and coping with the death of his mother. This court is uniquely situated to perform a delicate balancing necessary to accommodate.
Counsel, his carceral sentence is 2 years above the minimum, correct?
Correct, Your Honor.
And you want us to go to 5 years, the absolute minimum, correct?
That's what we're requesting, Your Honors, but if Your Honors, find it more appropriate to give him 6, we would take that as well. The point of our ask.
The victim was present with his family at the time he was stabbed, correct?
That's correct, Your Honor. And this hasn't stopped. This is no doubt a serious incident, but Mr. Morant was delusional. He had believed for weeks that he was being chased and harassed. He carried a weapon to protect himself. He believed that he was the future commander of the CIA.
Counsel, he hasn't been diagnosed with a psychiatric illness, has he?
That's correct, Your Honor. It's true that he hasn't been diagnosed, and this really speaks to sort of how discreet and short this period of unmanageable psychosis has been for Mr. Morant. I think Mr. Morant said during his 7:30 evaluation that he had been hearing voices as a child, but he also refused to speak to the 7:30 examiners. And that also just, first off, that doesn't really speak to how he would respond to treatment generally. It just sort of speaks to the situation at the time.
Counsel, was he in treatment at some point?
What was he, sorry?
Was he in treatment at some point?
No, Your Honor. The first time that this sort of came up, and unfortunately this is the case for many mentally ill people, was when he was referred to Bellevue Hospital as an emotionally disturbed person just 3 months prior to this incident. And instead of, putting him on a 72-hour hold.
So you're saying that the onset of it was in his early 20s, is that
Yes,
basically that's what you're saying?
Yes, he was around 26 at the time this happened. And this was a very, very special time. It was very, very difficult for Mr. Morant, and he had been living with a lifetime of mental illness and had no violent tendencies, exhibited nothing at this point. He had been living independently. He was gainfully employed. He stayed
Counsel,
out.
how do you respond to the observation that he sharpened the screwdriver beforehand, correct?
I mean, again, he had been battling lots of delusions prior to this. He believed people were after him. He was sleeping on the subways, which is where this was happening. And he kept the screwdriver on his person. And even though the victim was a stranger, when he attacked him and immediately called the police on himself, handed them the weapon, and then told them that he had done this, he believed that that person, the stranger, was someone who had been harassing him for the past few weeks on the subway. Mr. Morant, this was a very short, discrete period. Now, and because of this incident, it's unfortunate, but because of this incident, we now know he has a severe mental illness. And what we're asking—
As my colleague mentioned before, the stabbing here happened in front of his children.
That's correct, Your Honor.
And what should we make of that?
Again, this was no doubt a very serious and traumatic incident for the victims, but this has, if I may address Your Honor's question.
Thank you. You have time in rebuttal.
Okay, thank you.
Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people. Mr. Morant entered the subway system with a sharpened screwdriver, approached an innocent family, complete strangers, enjoying a day in the city, and attempted to kill their father by stabbing him in the arm and then in the chest with that sharpened screwdriver. A 7-year prison term was, given those facts, remarkably lenient. And I would point your honors to, in fact, some of the case law that opposing counsel cites to, even in instances where a defendant has been found unfit to stand trial, 7 years is more lenient than what other defendants have gotten for similar crimes. The case is People v. Reyes. Mr. Reyes was a diagnosed paranoid schizophrenic. Counsel relies on it, was found unfit to stand trial, received 10 years in Supreme Court, and on appeal, this court reduced it to 8. And again, that's still a year more than Mr. Morant received here. This is, by any definition, a reasonably lenient sentence for what happened here. The court was fully apprised of Mr. Morant's mental illness, as were the people when this offer was made. And
Counsel, you emphasized that he underwent a CPL 730 evaluation.
yeah,
And that he was found fit to proceed to trial.
yes.
However, didn't the evaluators say also that they weren't able to rule out the possibility that he was operating under some delusion or ideation?
The upshot of the 730 exam was that defendant largely refused to participate in it, although he was found fit to stand. But again, Judge, we're not contesting that Mr. Morant was unwell when this event happened. But at the end of the day, this victim was traumatically injured. He had his arm around his 9-year-old son when this screwdriver was driven into his body. This is an incredibly serious crime. It happened on the most important and most sensitive public space the city has within the subway system. It was in the middle of the day. Again, this is not to undervalue or downplay Mr. Morant's mental illness. This is just to say something has to give when an incredibly serious crime is committed.
You're saying that given that he has mental illness, the sentence is still fair?
In fact, Judge, I would say the sentence was decided on precisely because of his mental illness, or at least in significant part because of his mental illness. Had he not been mentally unwell, had this been a pure act of cold-blooded cruelty with no
Been asking
intention,
for much more than
I think he would have gotten very close to the maximum for a crime like this. So I think 2 years above the minimum for a crime of this brutality and this cruelty is more than fair, even generous. If your honors have no further questions, I'll rest on our briefs.
Thank you, counsel.
Just to return to your honors question, this was, again, a very serious incident. We're not downplaying that, but this court and the Court of Appeals have said that, mental illness sort of mitigates culpability, and this court has reduced a sentence as recently as last week for cases where it's similar, like psychotic breaks, and in incidents where the victims were more seriously injured. And again, what we're asking for is to reduce Mr. Morant's sentence so that we can get him into mental health treatment. That's what we're asking for. For someone like Mr. Morant, 2 years is a very long time to go without proper treatment. And that's what we're arguing for. And what we're asking isn't that we release him without any safeguards in place. What we're asking is that he be allowed to start post-release supervision for 5 years so that he can begin intensive mental health treatment, so that with his parole officer can connect him to housing and employment, which he didn't have during this period, so that he can actually begin to treat what we now know is a serious mental illness. And the other thing is, if he violates post-release supervision, if he doesn't participate in treatment, and if he remains non-responsive, he can be reincarcerated for that. So the only way Mr. Morant would be benefiting from a reduced sentence at this point, the only way he would benefit is if he successfully completes 5 years of post-release supervision, Your Honors. And 5 years of post-release supervision where there's mandated mental health programming will make our community safer. If there's no further question, I'll rest on my briefs.
Thank you, counsel.
Thank you.
Both. Branch Banking and Trust Company v. Juliet Coot. Please.
Good afternoon, Your Honors. Michael Carlson for Appellate Juliet Coot. As the court can see from the record, the plaintiff several times pawned off the certified mail documents for the notice of default as if they were the ones for the RPA PL 1304 notice. The RPA PL 1304 notice, of course, has to go certified and regular. the notice of default doesn't have to go certified, but if they so choose to send it certified, they can. And, you know, they had the record that matched that tracking number, but it didn't match the tracking number for the RPA Appeal 1304 notice, but it was presented as if it was in their motion, which tells us one of
The
two.
Russell affidavit conjoined with the log that he used, isn't that sufficient? You don't need the certificate of mailing numbers to line up if you credit his affidavit.
Well, all right, that's another point, being the log is apparently 11 days after the fact, because it says July 21st to reference a mailing allegedly
But
happening July 10th.
counsel, is that dispositive? The fact that what was recorded was reported at a later time? Don't we have case law that says that that's permissible?
I mean, it says it's a bit more to the effect that it has to be at or near the time of the occurrence. And the Rosicki law firm with 3 offices, they were handling a lot of foreclosure cases. If they were sending out these notices, they were sending out high volumes of them. It's hard to remember 11 days later, did I really send that 11 days ago, or was it 9, or was it 14?
That's speculative, you know, and just going back to, you know, what my colleague said, we have the affidavit, we have the mailing log, and then you have the letters. And above each letter, there is a USPS number, although it may be the incorrect one as stated in the papers, but obviously the mailing was done in accordance with the dates listed in the log.
But then the mere fact that it shows up as the certified mail slips for the notice of default are presented as if they're for the 1304 notice indicates some degree of disorder and disorganization in their record keeping. If there was not a disorder and disorganization in record keeping, or unless they were trying to really deceive the court, which I hope that wasn't the case, then their records shouldn't be relied upon as being something that the court can pass summary judgment based upon. If they don't even know which receipt goes to which mailing, it doesn't seem that their records are something that the court can rely upon to grant summary judgment.
Well, let me ask you this question, because my colleague did indicate to you that, you know, there is case law indicating that, you know, a record of something occurring, you know, a week or more is reasonable. My question to you is, do you have case law that states the opposite? Because, you know, 11 days is reasonable. Based on the case law, do you have something that indicates that it's unreasonable?
I would say what the cases say is within a reasonable time thereafter.
Right.
And I think that a high volume mailing is something that would need to be kept track of on a lot more contemporaneous basis. Other things could be logged differently, you know, certain things that don't happen in such high volume. If you were selling cars or something, and what date did you sell a car? You know, you're not doing as many, you're not selling 100 cars a day.
What are you basing it on?
Just that, I mean, that to be acceptable as a business record exception to hearsay rule, also nobody really lays a foundation for the letter log either. Nobody explains how it was created, and it was apparently created by Rosicki, and the other witness from some other organization doesn't necessarily lay a foundation for that. It's just thrown in with a bunch of other documents. So I don't think there's a foundation laid for it as a business record. And I also think the contemporaneous issue is a problem with high volume mailing, because they would have been sending out hundreds of these things, you know, within a week or so. They had a lot of cases. I had a lot of cases with them, so I know that they have high volume. They had 3 different offices throughout New York State: Batavia, Fishkill, and Long Island.
Counsel, before you sit down, you also make the point that somehow the mortgage and the note weren't established at the hearing. Why was that necessary if it had already been found by the court that there was a note and there was a mortgage?
Well, the actual terms thereof would need to be relevant as far as the referee hearing, that, you know, because of the referees calculating the interest and things like that. So even if all the summary judgment is just concerned with is whether they were in possession of a note, not necessarily what the interest rate there is in, when do the late fees apply, and the nuts and bolts of the amount as the referee would deal with. I also would object to the idea that we should have to use some QR code to verify.
Counsel, you can expand on that on rebuttal.
Thank you.
Good afternoon, if it pleases the court. David Gans for the plaintiff respondent. I believe if you look at counsel's papers, he's confusing, there's two motions here. There was the prior motion and the renewal motion. With the renewal motion, the affidavits that were included had the proper, removed the document that which counsel claims was an error and has the proper tracking number that properly references the 90-day notices. Additionally, the log entries were contemporaneous to the mailing, as 11 days was within the time. And even without that, there's two ways to prove mailing. One is either by actual proof of mailing, and one is by standard policies and procedures. The affidavit sets forth the proper policies and procedures that were set forth, and therefore also can be relied on to establish the proper mailing of the 1304 notices. Additionally, there was clear knowledge as to defense counsel's claims as to the knowledge of the witness. He clearly established his knowledge of the mailing procedures as well as the documents that were set forth in the hearing, such that they do set forth a way of establishing the amounts due, and therefore judgment of foreclosure sale was proper, as was the summary judgment. If the court has any questions for me, I will rest on my briefs.
Thank you, counsel.
Thank you.
Yes, Your Honor. I believe that the records are disorganized. The Rosicki firm later was closed down. They got in some degree of trouble, and I don't think that the disorganized records where it's possible for one certified mail to be pawned off as if it's pertains to a different document.
Counsel, you know, you're making a bit of sense here. I will say it's true. I remember the Rosicki firm, and they were a volume business. But do you have any case law that backs up the inference that you wish us to draw?
I mean, not per se as to a precise number of days, but as to there's much of it. I can't think offhand, but many of the cases in terms of just the business records exemption say it has to be at or near the time of the occurrence. And I would just say that's relative depending on what business activity we're keeping track of here. If we're, watching ships sail, that's a different thing. There's not so many of them, but a notice that you're sending out, 50 of them a day, maybe, or 25 a day, that's high volume. And if you're keeping track of that, it should be kept track of in a more contemporaneous manner. But there's also the issue of no one laying a foundation for that record from Rosicki as to their letter log. So it's just thrown in there and dumped in with a lot of other papers, and nobody really, identifies it and lays a proper foundation for it.
Anything you'd like to add, counsel?
Besides just also my objection to the QR code, which Your Honors can read this in the brief.
Thank you very much.
Thank you,
both.
Thanks, Counsel.
Kent v. Bernstein. Please.
Good afternoon, Your Honors. May it please the Court, Matthew Cuomo for the appellants Stephen and Gail Bernstein. The Supreme Court simply failed to conduct the appropriate evaluation in this negligence case. This is a water damage case that stems from a historic storm Ida on September 1st, 2022. The Supreme Court made several errors. First was the issue of whether there was a waiver of a building obligation or the Bernstein's obligation to inspect terrace roof drains. Now, ultimately, that...
You cite that email to support your waiver argument, right? But that email was not sent to your clients.
No, it wasn't sent to the clients. That's exactly it, Your Honor. They didn't remind the tenants and shareholders in the building to inspect this. They reminded, or the building managing agent reminded his superintendent that it was the superintendent who had to do this.
Okay, you also have to get over the no waiver provision in the proprietary lease.
Well,
that's a little bit of a heavier lift. I know you would concede.
Your Honor, I think you have to look at it this way. It's 20 years the Bernsteins resided in this apartment with this terrace. In 20 years, no one had ever suggested to them that they had to inspect the terrace roof drain. They had to keep that elevated walking surface clean. That was,
Was there a storm like Ida in the 20 years?
I'm sure there were big rainstorms, but Ida was particularly historic. It resulted in a presidential declaration of disaster in New York. I mean, subways were flooded, and we've had a few of those over the years. It seems like the weather's changing a bit, maybe.
But not before Ida, right?
Nothing of that significance before, at least nothing that was recorded by anybody in the building. But more significantly, that obligation, such as it exists in the contract, does not create an absolute or strict liability scenario. As the Supreme Court did correctly recognize, it would at most basically give rise to a negligence claim. And that's this court's decision back from 2002, Touchage against Elm Management. So even if they did have a contractual obligation to inspect, it still has to be evaluated in light of the negligence standard. And that's what Justice Lattin failed to do. He made no mention anywhere in his decision about the negligence standard. Did the Bernsteins demonstrate prima facie with admissible evidence that they did not know of the two conditions? There were two conditions which caused this damage, not just one. There was the backup of the drain, and then there was the failed flashing.
Yeah.
And the failed flashing was clearly, regardless of what anybody else would say, was the building's obligation, and that's demonstrated by the facts that in the months after the loss, it was the building who inspected, figured out that the flashing was compromised, and then fixed it at building cost. So there was no evidence that the Bernsteins knew about these conditions before. There was no evidence that the Bernsteins actually knew or had created them, and there was no constructive notice.
Wasn't there a sick note that sounded off when?
That was, yes, Your Honor, during the storm, there had been an unrelated leak in that pipe chase from a pipe that ran through the chase. So the Bernsteins had put a little sensor in there, and that's what alerted Mr. Bernstein to the fact that there was water leaking during the storm, and that occurred during the storm. And the last error made by the court, by the Supreme Court, was the idea of it evaluated Mr. Bernstein's timeliness in terms of the response to knowing that the leak was ongoing. And somehow the Supreme Court arrived at the conclusion that getting notice of the leak while it was ongoing could somehow make the plaintiff's burden on demonstrating that they created or knew of the conditions before the leak occurred. So and that last phrase by Judge Lattin, that the timeliness of the response to the leak is an indicator that there may be negligence, that turns causation on its head. How could notice of a leak that's ongoing demonstrate that you knew about the potential for a leak before the storm occurred?
I guess that he was saying that he didn't, that your client didn't take fast enough action to remediate the problem once he was alerted by the bell. That's my understanding of that.
I guess that's what he was alluding to, but that does not preclude summary judgment on the idea that my clients did not create the condition or have notice of the condition before the loss occurred.
You make that point well in your brief, counsel. Thank you.
Good afternoon, Your Honors. May it please the Court. John Reclitus for respondents Janet and Harvey Kent. As Your Honors identified, it is undisputed that as part of the proprietary lease, appellants agreed to keep the drains on their terrace clear and clean at all times.
Counsel, haven't we held in numerous cases that there's no ongoing duty by a residential shareholder to conduct periodic inspections of its facilities?
Well, I'm not sure it's a question of periodic inspections rather than just there's a drain cover on this outdoor terrace, and both Mr. Bernstein and the superintendent have said that drain, which was covered with debris and which in a contemporaneous memorandum from the superintendent said that was when he removed that simply with his hand, that was what allowed the flooding to cease.
I'm sorry to interrupt you, but could the super visually inspect that debris, or did he have to lift up some paving stones in order to see it first?
He just used his hands to clear the debris. So,
but how did he get at the debris? Was there a paving stone above the drain first that he had to remove?
He didn't have to remove. I think what he did was he went in and additionally went under, but clearing the surface of the drain, that is the tenant's responsibility. That's what Mr. Bernstein has testified, that was what his responsibility. And that's what the superintendent said. They said, you're 9 years in the building, whose responsibility is it to clear the top of that? And that's where all the debris was. So Your Honor, I referred you to the incident report where he says the debris was covering essentially the cover of the drain. And once I cleared that, problem solved. All the flooding stopped and things got better.
Right. Now, let's return to the email that we started with.
Yes.
Now, does that show that, in fact, the building had taken responsibility for the drains and there was a waiver of the responsibility of the tenant to do so?
No, Your Honor, I don't believe it does. I believe that, that was a fail-safe. There was an emergency storm coming. And, again, waiver is not to be lightly presumed. There needs to be a clear manifestation. I don't think there's a clear manifestation that, the building's relinquishing it by the superintendent saying, hey, and this wasn't directed specifically to the Bernstein's deck. This was several buildings around the city saying, hey, make sure the tenant's decks are clear. So certainly not that and as you know, the Bernsteins found out about this email in litigation. So they weren't on notice, and they acknowledged, Mr. Bernstein acknowledged keeping the top of that drain clear was our responsibility. And he said we normally did that, but obviously, preceding or during the storm, they did not. So again, this is the, waiver is not lightly presumed, and it requires that affirmative, relinquishment of the right. And, additionally, there's this non-waiver provision in the lease that says, that we need a writing from an officer of the building, excuse me, saying that we're relinquishing the right. And there's nothing close to that. This is one email over 20 years. You would think if the Bernsteins had this course of conduct, they would have some other writing saying, hey, we're coming into the building to check your drain, something like that. But they
Mr.
don't.
Lipin also said that he didn't hear directly from the defendants, right? That it was the apartment 2 floors below that initially gave him notice that there was a water incursion.
That's correct, Your Honor. Mr. Lipin denies ever hearing anything from the Bernsteins, from Mr. Bernstein, the night of the storm. So he was directed by someone below them. And the Bernsteins Mr. Bernstein was aware through this water alarm going off that there was, the significant flooding going on. And he said, I didn't go outside because it was raining too hard. And, as far as I'm aware, there's not an exception in this proprietary lease saying, well, if it's raining really hard, you don't have to clear the drain. So, as an additional point of emphasis, they have to overcome not only this lack of proof of a course of conduct, but this non-waiver provision in the lease. So, and again, I would refer the court to the Probinder decision cited in our brief, very similar case where the court essentially said there are questions of fact with contributory negligence, causation, but when this happens, there's a deck that's clogged above on someone's terrace, and it floods into an apartment below. That's basically indicia of negligence, and you're not going to get summary judgment.
Thank you, counsel.
Thank you.
Your Honor, if I may, just to clarify the facts a little bit, counsel, I think, misstated the way the terrace is laid out. There's a terrace roof, and the drain is set in the roof. Above that is a walking surface that's created. So in order for the superintendent, Mr. Lipin, to clear the drain, he actually had to pick up a cover on the elevated walking surface, reach down about 18 inches to 2 feet to the roof below, and he was able to clear away some debris. So what Mr. and Mrs. Bernstein always acknowledged is that that elevated walking surface, the finished surface where they could walk along and sit on chairs, that was always their obligation, and they always kept it clean. And in the 20 years that they lived in the home.
Counsel, was there some indicia of how serious the situation was that actually the water had risen above the walking surface?
No, it didn't rise above the walking surface, but it was admittedly by Mr. Lipin's testimony just below it. And that's a testament to the fact that I think there was about 9 inches of rain in 5 hours. Now, Your Honor, the other issue, and I think it's important, whether this is a waiver or non-waiver situation is ultimately not relevant, because the standard is still the summary, is still the standard of negligence. Did they create the condition? Did they know of the condition? Or did they have constructive notice of the condition? And they did not. The evidence, the affirmative evidence on that is clear. They'd never had a similar problem. They'd never had a similar backup. They were certainly unaware of the second condition, which was the failed flashing.
Yeah, just to return to the waiver for a second. In your reply, you say that it's a matter of law, but to me, it seems like a classic issue of law and fact together. Like you have, the law part is what's in the proprietary lease, and then you have people's behavior.
It may be, Your Honor, in terms of whether there's the waiver, but presuming for the moment there was no waiver, and presuming for the moment that the Bernsteins had this contractual obligation, it's still evaluated under a negligence standard because the provision of the bylaws and the provision of the proprietary lease and house rules were not absolute or strict in their liability. So the court would have to default to conducting a negligence analysis. And that's completely what was not done by the Supreme Court in this case. They never mentioned the standard.
Thank you, counsel. Thank you both. Ravello v. RXR.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent the appellants on this appeal. It is the appellant's contention that the motion court erred in denying them summary judgment on the contractual indemnity claim against Eurotech. It is unrefuted that the incident arose out of Eurotech's work, so the only issue for this court is whether the appellants were negligent. With respect to the property owner and the lessor of the premises, Eurotech does not refute that they're free from fault. Their argument is focused on the general contractor, Hannigan. The legal precedent emanating from this court unequivocally holds that to hold the general contractor liable for negligence, they had to have actually exercised control over the means and methods of work, the manner in which the work was being performed.
You have a stronger argument, of course, with respect to RXR and Cahill-Gordon, but what about Hannigan's control of the workplace, the fact that there were some bags of some kind of work product at the base of the baker's scaffold? Didn't it have control over the trades at the place and where they placed their materials?
Yes, Your Honor, that is correct. However, with respect to the materials near the scaffolding, Eurotech's attempt to misconstrue this case as a premises condition. However, plaintiff unequivocally testified that those materials had nothing to do with his fall or the way he set up the scaffolding. Specifically, the question he was posed on page 172 of the record, when you were setting up the scaffold in the position it was at the time of your accident, did these materials cause any issues for where you would set up the scaffold basically? And the answer was no. Plaintiff also repeatedly and unequivocally stated that the only reason he fell was because the safety railings were absent on the scaffold. And again, I quote from plaintiff's own testimony. This is on page 159. Then I fell, but none of this would have happened, and none of this would have happened if they would have had a safety rail, and I would have felt that I was already outside the scaffold. He indicates
There's also testimony from the plaintiff that the scaffold couldn't be set up safely because the cement bags were located too close.
There was a bit of equivocating, but at the end of the day, plaintiff unequivocally stated that the materials did not contribute to the fall. The scaffold was set up evenly. It was not rocky. It did not move as a result of the materials. Plaintiff did not come into contact with the materials. He expressly and repeatedly blamed the accident on the safety railing, and that's why the premises condition analysis is not applicable in this case at all. Now, with respect to the means and methods, the testimony is unequivocal. The plaintiff was solely supervised by his employer, who provided the scaffold, the materials, told him when, where, and how to do the work. Hannigan's responsibilities in that regard were general oversight, trade coordination, stop work authority. This court has repeatedly and unequivocally held that that's not enough to impose liability. Unless the panel has any further questions, I'll rest on my brief.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. Julia Audibert with Wilson Elser for Eurotech Respondent. May it please the court, I will start by just saying this court did acknowledge the second question that the plaintiff received on page 172 as to he didn't feel he could safely set up the scaffold. So I will then note, even if we assume that, okay, fine, the railings are the focus of this case, if we give that, then there is testimony from their superintendent that he walked the site all day, every day, constantly. And there becomes a question of fact as to whether they had notice of the railings, because he also testified that he would personally take unilateral action to correct any unsafe working conditions.
Gorman now?
I'm sorry, the superintendent of Hennigan, I apologize. Keith Bullock on page 323 of the record.
But counsel, wasn't it Eurotech's person who indicated that the scaffolding was to be the type of scaffold that was supposed to be used for this work? And Hennigan had no control over what was used to do the work.
Hennigan's control, though, takes it out of the typical case that this court sees where they may have general supervisory authority or the authority to stop the work. It's not just that level here. They have this added level where he testifies that while in those cases, typically the superintendent of the general contractor may go to the representative of the subcontractor and say, hey, fix this. You know, you have an unsafe working condition here. You need to figure that out before you continue your work. Here, he personally says he had the authority to himself remove any conditions. And with the scaffolding, he testifies specifically that if he had seen the railings not attached to the scaffold, he would have made sure that they were reattached. He says that not only that, he then also says that no, he would not go up to whoever the representative was. Instead, he would, again, take that action himself. And that's important because it brings questions of fact as to, again, whether they had notice of the missing railings, and if they did, if they should have taken that.
Who directed the plaintiff to use that scaffolding to do the work?
The plaintiff was certainly he was doing Eurotech's work, and it was Eurotech's instructions as to how he was installing the.
When he was looking for the railings, which person or company did he go to find the railings for the scaffold?
He testifies that he looked for a Eurotech representative. Eurotech does refute that conversation ever happened, that we'd never. Eurotech disputes that we ever told him that he should not have the railings or that he should continue work without the railings, but he does testify that he went to look for a Eurotech representative, if that answers your question. And so, again, the testimony of their own superintendent, however, creates these issues of fact as to whether their negligence, creates issues of fact as to whether they were negligent in failing to remedy any unsafe working condition, which here simply requires the dismissal of the denial of summary judgment. The Supreme Court correctly found that. They cited to the superintendent's testimony in making that decision, and therefore the order should be affirmed. Thank you.
Thank you, counsel. One minute, you asked for it.
Good afternoon, Your Honors. May it please the court. Jack Lockwood for the plaintiff's respondent. I'm addressing the argument made by the defendants in their brief. It's their last point heading that the Supreme Court erred in granting that branch of plaintiff's motion, which was for summary judgment.
Don't we need to know something about what Mr. Ravello may have done? I mean, I know he's got a ruling on liability for 240 sub 1, but for this indemnification issue, couldn't his negligence, if it's proven at trial, diminish the possible negligence of Hennigan?
Plaintiff's negligence is not an issue in this case once 240.
Not as far as you're concerned, but as far as
we're concerned, yes, Your Honor. 240 is not an issue in this case once.
No, I agreed. I'm saying doesn't it relate to the indemnification issue? That's the only question I'm asking.
Yes, we don't think that we're not taking a position on the indemnification issue, Your Honor. Our position is just that this court should affirm that branch, the portion of the order which dismissed the affirmative defense of comparative negligence asserted against plaintiff. I'm out of time. Thank you, Your Honor.
Thank you, counsel. Please.
I would just like to address Eurotech's comment with respect to unilateral action. Hennigan's witness testified that if they saw an unsafe condition, such as a ladder, he wasn't actually talking about the scaffold, but that he would remove it. And it is the appellant's position that falls exactly under the same...
Microphone a little closer, thanks.
It falls under the exact same series of facts as the general contractor's overall authority to look at overall safety, to stop work. It falls within the same category.
Was the testimony that the Hennigan person would remove that specific scaffolding if they had seen it without the railings?
No, Your Honor, Hennigan actually, I think, is aligned with your tech with respect to the scaffolding where the railings should have been on in the first place at that height. The testimony about removing unsafe equipment, quote unquote, if I'm recalling correctly, it was referring to a hypothetical about, let's say you saw a defective ladder. It was a hypothetical.
So it was a general safety issue.
Absolutely.
They were
general
questioned
safety
about.
issue, yes. Unless the bench has any further questions, I'll rest on my brief this time.
Thank you, counsel. Thank you all. People v. Hernandez.
Good afternoon, Your Honors. May it please the Court. Cara Labini from the Center for Appellate Litigation on behalf of Mr. Hernandez. Mr. Hernandez had a right to a jury's determination of the amount of the victim's losses before restitution became a part of his sentence.
Not according to Horn.
Horn,
What do we do about that?
this court is not bound by Horn because there has been significant intervening law that interprets the federal constitution that this court is bound by. So the Supreme Court's clarification of the Apprendi standard in Blakely, its extension of the Apprendi right to criminal fines in Southern Union, and the High Court's decision in Ellingberg, which is just from last month, which I submitted as additional authority to this court yesterday, does bind this court. And I think the inexorable conclusion that follows from those decisions is that restitution entitles a defendant to a jury's verdict, to a jury's determination of the amount.
That would in essence be a
losses.
finding that Horn was wrongly decided.
I'm sorry, Your Honor?
That in essence is a finding that Horn was wrongly decided, right?
No, it's just reconciling it with updated case law that refines the Apprendi standard. I think this court is bound by Supreme Court interpretation of the federal constitution. So this court should apply those precedents and update Horn. Horn is now 24 years old. There's been significant development in Apprendi jurisprudence since then. And I think it's clear now from those decisions that any fact that increases the sentence, a jury is required to determine before it can serve to increase the defendant's sentence. The jury here did not find any facts relating to the
Oh, we know
victim's
that.
losses.
We know that. Tell us expound on the most recent Supreme Court precedent for our benefit.
Sure. So as background, there's sort of two lines of case law that has found my argument unpersuasive. The first line says that restitution is not criminal punishment. Ellingberg, the case from last month, or January rather, puts that to rest. Restitution is definitively criminal punishment. That falls within Apprendi. The second line of cases that has found my argument unpersuasive finds that restitution does not fall within Apprendi because somehow there is no statutory maximum pertinent to restitution. But we know that doesn't make sense for several reasons. One, in Southern Union, which again extended the jury right to criminal fines, there was also no cap in that case. There's another way to look at that also, which is that no amount of restitution was authorized by the jury's verdict. And Blakely says that the Apprendi analysis comes down to whether the sentence is authorized by the jury's verdict. Here, it was not. So any amount of restitution—
That was sort of Justice Gorsuch's point in his dissent, but he only got one vote for that.
Right, Sotomayor and Gorsuch, certainly. There have been many dissents in the circuit courts. There's been much commentary about this, many cert petitions, and ultimately somebody has to be the first. I think that the Supreme Court's decision last month chips away at Horn's logic and other federal circuit decisions in this area.
Why wouldn't the first be the Court of Appeals and for us to follow Horn?
Well, I think this court, again, is bound by federal interpretation of the federal constitution. So
what is it exactly that's been interpreted vis-a-vis the federal constitution that makes Horn inapplicable now?
So Horn found that restitution does not require a jury's determination because—
Is that what they found, or did they find that it didn't apply here because there was no cap?
So right, that a jury was not required to determine the amount of the victim's losses because in New York there
It
was no
wasn't an
cap.
extension of it wasn't an enhancement of the penalty, right? Because there's no cap.
Right.
That's how they ruled it.
But because of Southern Union, we know that that's no longer really has a leg to stand on. There was no amount of restitution that the jury's verdict authorized here. Yes, in theory, restitution is authorized when you have a criminal conviction and there's some amount of losses. But the prosecution has to prove those losses and in order to assess restitution properly. It's also a nonsensical argument now. If the legislature had capped restitution at $100, my opponent's view is that therefore then he would get the jury right because it's capped. There's somehow a statutory maximum that's fixed. But because he can be assessed up to $1 billion, he somehow loses that jury right. It doesn't make sense, and we know that it's wrong under Southern Union. For that
Thank you,
reason,
counsel. You have time in rebuttal.
thank you, Your Honor.
Good afternoon. May it please the court. Christopher Marinelli for the people. Horn does control. There has been no intervening precedent that calls it into question. In Southern Union, the Supreme Court said, quote, nor a fortiori could there be an Apprendi violation where no maximum is prescribed. Reviewing the history of fines, they view the statute at issue as having a cap of $50,000. And then there was the impermissible factual finding of days. The way Second Circuit in Bengus and many other courts have distinguished that from the restitution statute is to find that it does not have a cap. And you are correct, that was the Court of Appeals reasoning in Horn. Ellingberg doesn't change the equation. That is just bringing the Eighth Circuit into line with, I think it's 9 circuits that already found the federal restitution statute to be criminal. They had rejected this argument. Obviously, Hester is a dissent. I think the tell in that dissent is to say, usually it's 0. That's just kind of shows it's statutorily authorized. And I would say the argument's parallel. The arguments have been rejected in the context of the discretionary persistent felony statute, where you have like the regular range for the crime, and you have an upper range. And what the Court of Appeals has said about that is, like, it's the crime itself that exposes the defendant to those sentences, and then the court makes findings about whether to find the defendant a persistent felon. And as the court stated in Prindle, that has survived scrutiny in the test of time. So we do think this is clearly controlled by Horn. Unless the court has any questions, we'd ask you to affirm.
Do you want to address Ellenberg for a moment?
Ellenberg. I mean, I don't think Ellingberg changes anything, because I think it generally has been treated. Most authority has treated it as a criminal sanction, including, like I said, the Second Circuit. In Bengus, all these circuit courts, they're treating it as a criminal sanction, but finding that Apprendi doesn't apply in the absence of a cap. And the Second Circuit even, its decision at Bengus, follows Southern Union and discusses that. So, like I said, Ellingberg doesn't really change anything. It just brings the Eighth Circuit into line with the weight of authority about the nature of the restitution.
Anything you'd like to add, counsel?
No.
Thank you.
Thank you.
Blakely versus Washington says that a judge may not, quote, inflict punishment that the jury's verdict does not allow. Restitution is unquestionably punishment. Even $100 in restitution, let alone what Mr. Hernandez received, which was over $14,000, can't be assessed without further fact-finding. The jury was not involved in that fact-finding, and so the maximum punishment on the basis of the jury's verdict was $0 in restitution. This court should remand for a jury trial on restitution and vacate the order. Thank you, Your Honors.
Thank you, counsel. Thank you both. Leven v. Salvini. Please.
Good afternoon, Your Honors. Samuel Butt from Schlam Sonadolan for appellants. May it please the court. There are two issues on the liquidated damages clause. The only question for the trial court was whether the damages were reasonably ascertainable at the time of the contract, or whether the amount at issue, the $1 million, was grossly or conspicuously disproportionate.
How much weight should the court have given Mr. Levin's characterization of this provision, the liquidated damages provision? Because he kept using words like penalty. You know,
Your Honor,
if he'd been advised properly by counsel, he would have said other things. But he said these things, and it made it sound like they kind of pulled the $1 million figure out of thin air. So what is the court to do about evaluating that testimony?
Your Honor, the question and the finding the trial court had to make was whether the amount was grossly disproportionate. Mr. Levin's view is entirely irrelevant. Indeed, the question of whether the provision is enforceable or not is a question of law.
Doesn't it go to how Mr. Levin and the other people, the other contributors thought about this? Isn't that important to know about whether it was anchored some way to the inability to determine damages?
Well, I have two responses to that. The first is no, a party's intent is not relevant. That's clear from this court's addressing systems versus Friedman case, which is cited in our brief. And it says, quote, "The fact that a liquidated damages clause was designed to provide an incentive not to breach does not transform such a provision into a penalty merely because it operates in this way as well as the Court of Appeals in Bates Advertising similarly holds that it does not matter the party's intent, so the fact that a liquidated damages provision may disincentivize a breach is irrelevant to the determination. Also, there was plenty of factual evidence from Mr. Levin that, as well as Mr. DiPalantonio, as to the reasonableness of this amount. They testified both that it was based on the revenues that Levin, or the fund,
it had
historically been getting, as well as
I'm sorry to interrupt you, counsel. The fund had profits of $1 million a year around the time that this went into effect. Is that right?
I had revenues that, yes.
Profits.
The testimony was...
Doesn't that look disproportionate to have $1 million penalty for a violation of this clause?
Again, Your Honor, the question is whether there was any... first of all, the courts have found that 2 to 3 times the amount of actual damages is not disproportionate. This court found that in Seymour v. Hovnanian. Further,
in those cases, it's an attempt at figuring out what the probable loss is, right? There was no such attempt here.
Well, Your Honor, that's exactly the point. With respect to the court did not. You can look at the paragraph, the Justice Sector in her decision, and there is no discussion of disproportionality. It is entirely focused on the.
But the court can look at the record, right? The facts in the record to make a determination about that. And in looking at the facts of the record and what was being discussed, the court was able to see how this issue was being discussed when the amount was being determined. And there's nothing within the record that even suggests that it was based on probable loss or anything. It just sort of was a number that was brought about, right?
Well, I disagree respectfully. There was evidence in the record. Mr. Levin and Mr. DiPalantonio testified that it was based on the revenues of the fund as well as the new contract.
But if the revenues of the fund were only $1 million, and then the amount for the liquidated damages was $1 million, how did the revenue plus the amount of the damages, where within determining that was there any discussion about what the probable loss was? Because the loss couldn't be the entire amount that the fund made, right?
Your Honor, well, there's a distinction between the revenue and the profits. The revenues were closer to $14 million, and there was also testimony in the record that someone taking a client, as the defendants did, away from the fund and its operating companies could easily have caused that amount of damages with respect to the revenues.
In 2014, the fund before tax revenue was $1 million.
Those were the profits, Your Honor. The revenues were 14 million. And I can find the site on my rebuttal if Your Honor would like.
You'll have time in rebuttal, counsel. Thank you.
Good afternoon, Your Honors. Eric Lindquist for the respondents. May it please the court. I want to begin by addressing a case that I missed in my brief, and that was referred to in the reply, and that is the GFI Brokers versus Santana. That's a case that, according to the appellant, has very similar language in its liquidated damages clause that was found to be acceptable. And the language in that case was that that it was payable in addition to all other obligations and to other remedies available to GFI. The language in our case is that it is other applicable damages in accordance with the general rules of law. So the general rules of law implies not the specific holding of a series of cases, it's the general rule. And the general rule is that there is no, that liquidated damages cannot coexist with the right for
'cause
actual
it implies
damages.
that damages, actual damages are ascertainable. In other words, to allow, the provision you just quoted presupposes that actual damages are ascertainable, and therefore you don't need liquidated damages to have some quantification in the absence of perfect information, right?
Well,
I'm agreeing with you, counsel.
Thank you, Judge. I think, well, I certainly agree with you. But my point is, that's right, but the point is that this gets us past, that there is ambiguity here, at least, in the use of the word general creates an ambiguity. What does it mean, general rules of law? That ambiguity lets us get at the party's intent, which is the lodestar of contract interpretation. You get into the party's intent and you find that they had no intent with regard to.
What about the negative example that they had previously of Adriana Barrocal's leaving, and that caused some problems to the company when she left, they said. And that was when they upped the fine to $1 million, right, above 20K?
That's correct.
So isn't that enough to provide some quantification of the damages that might be incurred by someone else violating the non-compete clause?
Well, there was no evidence of the actual damages caused by Ms. Barrocal's departure. So it's really not possible to compare the situation.
And the information we have in the record is simply that they thought that a fine of $20,000 was too low because it would cost more to prosecute an action, right?
Correct. That's correct, Your Honor.
But you do concede here that the profits were not readily ascertainable in order to come up with a liquidated damages amount, right?
I do concede that. I couldn't figure out how we would determine the profits readily. The point is that they are going from $20,000 to $1 million, a 50-fold increase, without any consideration of the actual damages, and without any effort to determine what had been the damages in the Barrocal situation.
But given that it's your burden, right, to prove that this liquidated damages clause is not applicable, right?
Correct.
And did you meet your burden here?
Yes, we did, Your Honor, because for one thing, that 50-fold increase without any justification is prima facie evidence that there was no connection to the amount of actual damages. And the record supports that. There was no discussion among the parties of what the actual damages might be.
And counsel, as my colleague had indicated, that it would be less expensive to raise the amount of the fine rather than to engage in litigation. I believe it was also Leven and Salvini that also indicated that a $1 million figure would avoid the situation of another partner leaving the fund.
Exactly, Your Honor.
Because actually they said, listen, There's no mathematics to this when it came up with the numbers. It just made common sense.
Right, which is not a determination or an estimation of actual damages. While I still have a little bit of time, I want to address there's an assertion in the reply brief that we did not preserve for appeal a couple of arguments, and I'd like to point out that we did do that. The one argument is that P47, the exhibit in question, is inadmissible because the documents underlying it have not been demonstrated to be admissible, and that this was not raised. It was raised in the conference before the court pre-trial. There was a discussion of the fact that the underlying documents had to be admissible, and there was no...
So that argument was made in front of Judge Schechter.
Yes.
She did exclude the exhibit, of course.
Correct. Thank you, Your Honor.
Thank you.
Your Honors, I would just like to say, as the court has pointed out, the burden was defendants. There is no evidence in the record as to what the probable loss might have been. Therefore, there was no basis for Justice Schechter to conclude that the amount was conspicuously or grossly disproportionate. And indeed, her decision says nothing at all about disproportionality and focuses on the intent of the parties, which is not the proper test. With respect to the argument regarding 13.2 and the GFI case, I would just posit that the language here, the general rules of law, means the same thing as the language in GFI. New York doesn't allow both actual damages and liquidated damages. Therefore, 13.2 could not have been allowing actual damages and is not a basis to invalidate the provision. And then I want to briefly turn to the actual damages. Should this court affirm Justice Schechter's ruling as to the liquidated damages, she precluded the plaintiffs from putting in evidence as to actual damages. That was Exhibit P47. It was a summary based on the voluminous exhibits rule. All of the documents were produced in discovery. They would have been business records had Mr. Leven been permitted to testify about them. The admissibility and foundation would have been laid.
Judge Schechter also said that should have been brought in as a motion in limine. And
correct.
Prior to the trial.
Correct, exactly. This was done 3 to 4 days before trial. We argued it was late.
No, I think the motion in limine would have to be brought more than 4 days before the trial.
Yeah, I absolutely agree with you, Your Honor. I'm saying that the application by the defendants was done 3 or 4 days before the trial, and that's when the evidence was excluded, therefore significantly was significantly prejudicial to...
No, the question is, why didn't you do a motion in limine to get a ruling on whether or not that would be allowed in at trial?
We didn't know it was at issue until the defendants raised it.
Would be in her part rules.
Your Honors, we had submitted our exhibit list in January. The trial was delayed until May. There was no motion or any indication from defendants that they were going to object to this exhibit until 4 days before the trial. Thank you, Your Honors.
Thank you, counsel. Thank you both. New Empire Builder v. Onboard Hospitality. Please.
Good morning, Your Honors. Robert Lum for the appellant plaintiff New Empire Builder Corp. There are 3 undisputed facts in this case, and that is first the principal of Onboard Hospitality, that's the defendant in this case, clearly testified that he has documents that were in a physical cabinet in a hotel that he owns.
He later backtracked about whether there was a written Sands contract, but there were other documents you said that he testified to that he never backtracked on. Is that correct? You make that argument?
We make the argument that not only did Mr. John Sharma, the principal of Onboard, provided Jackson affidavit stating that there are no other documents, and this was an affidavit submitted in December 2024. Those documents that we requested were the contracts relating to the work that Sains allegedly performed to repair and complete the foundation. Not only that, but also the scope of work, which would be submittals, drawings that a typical construction project would require in order for a contractor to fully and adequately complete the project foundation. That was not produced. We come to learn in June of 2024 that the documents were in a cabinet in his hotel that he owned. He point blank stated that I can go down and get a copy. I asked him several times, and this is not just one instance, about these contracts and the documents pertaining to Sains and the project foundation. He testified again and again that he has those documents and, quote, yeah, I can go through my documents and provide him the copy. When he refers to him, he means his.
So the
his
defendant
attorney.
makes the argument that the documents you sought in your June 21 demand were somehow in derogation of the court's earlier order in June. I think it was the second compliance conference where she said no more document discovery. But in fact, what you're saying is that you previously sought these documents from the get-go. Is that right?
That is correct, Your Honor. We requested for these documents from the get-go. We filed a motion to compel, and subsequently that was withdrawn with the understanding by counsel that he would procure two Jackson affidavits from the entity Onboard Hospitality. He procured the affidavit of John Sharma and the affidavit of Praveen Benedict, the administrator who's responsible for the office files. And so after the affidavits were procured, we withdrew that motion to compel. There was no reason for us to believe that this was a sham. We come to learn in May and then June that these affidavits were contradicted by the testimony of Mr. Sharma when he point blank stated several times that he has physical files relating to the project construction. And therefore, we filed a motion on June 28th to compel and for sanctions, and which the court ultimately denied.
Counsel, let's pivot for a minute to the note of issue question. Sure. Now, Upside, another defendant in the case, has filed a note of issue, right? So does that solve the problem?
Upside has filed a note of issue, but that
you've moved to vacate that note of issue, right?
I'm sorry?
Did you move to vacate the note of issue filed by Upside, or was that only the other side that did that?
Correct. The the note of issue filed by Upside, we did move to vacate that because the issues with discovery has not been resolved.
So that's still sub judice, right?
I'm sorry?
The motion hasn't been decided. No. Yeah.
No.
Right?
No.
Okay. And is that in front of Judge Sokoloff?
It's.
Do you know?
We went before Judge Sokoloff, but it has been pushed back to Judge Bannon.
Oh, it's in front of Judge
Bannon. It has not been decided.
But it has not been decided. Okay, thank you. Counsel, I know you're absolutely allowed to sit. I understand from your correspondence with the court that unfortunately you're having back problems. But if you can move the microphone as close as possible. So
that's what I was going to ask.
That's pretty good.
That work for you? May it please the court, my name is Austin Graff. I am the attorney for the defendant respondent Onboard Hospitality. Thank you for accommodating me by permitting me to sit during oral argument. It is a very simple dispute between a property owner in Onboard and the general contractor New Empire over whether Onboard owes New Empire additional monies based upon the construction it performed on the subject.
Counsel, you heard the back and forth we just had about the Sands documents, and I understand that Mr. Sharma said that, oh yeah, there was no written contract with Sands, okay. But counsel is asking about other documents concerning the Sands work that Mr. Sharma talked about. I guess, what would those be? The requisitions, the applications for payment, et cetera. What happened to them?
So what happened is the owner's rep retained this company, and worked with them. We do not have any documents. Any documents that we have, we've turned over. We have released hundreds, if not thousands of pages. This was the Sands was a company that came in.
No, I know you make the point that they could have done third-party discovery, and that's an argument to make, of course. But what about the fact that Mr. Sharma seemed to say that I got a locker with some Sands documents in it?
Yeah, but he doesn't say that.
Okay.
So I'll refer you directly to
Please.
page 189, page 243, and page 244 of the record, which is the word cabinet is the only place those words appear. And he talks about that that his records are sometimes kept in hard copies in a file cabinet or on the cloud. That's page 189. And page 243 is the question is, do you have a copy of the contract, the Sands contract? And he says, I have it in the file cabinet. It should be in my file cabinet. But at the time, he thought it was a written contract. He later found out it was a verbal contract. So that's the
Counsel, how do you deal with his testimony regarding the Jackson affidavit, where he essentially said that he just signed what his lawyer told him to sign and did not actually do a search for anything?
When I heard the testimony and I was the attorney who drafted it, I was shocked.
Oh, okay.
I always tell my clients, read, make sure it's truthful and complete, and then he sent it back to me. I didn't know that he didn't undertake the investigation it says he undertook. And there's no more documents. I mean, there is nothing else out there. This is a breach of contract, a mechanics lien, foreclosure, and unjust enrichment. The documents they're looking for is work done after New Empire left the job site. It has nothing to do with the damages. It has nothing to do with what work they performed. The Onboard has no offset affirmative defense and has no offset counterclaim. It's irrelevant. Whether we spent $1 million or $500,000 on the contractor after they left the job means nothing. It's what they did. If we had an offset claim, 100% understand.
So in terms of their request for discovery as it relates to this contract with the other contractor, there is no written contract, right?
My client says there is no written contract that's from his. So the man who told him that it was an oral contract is a man named Biren Patel. He's business partners with the principal of New Empire. He says that there was no written contract. He said it was an oral agreement and it was done with the owner's rep. So it doesn't exist. I can't give what doesn't exist. As with respect to the note of issue, yes, it was filed subsequent to this appeal. We did move to strike it. We also moved to dismiss the entire case because, to be honest, we don't know what happens when the court says you can't file the note of issue. How do you get to the next step? How do you get to trial?
Didn't Judge Bannon tell you to go to mediation? And I think we were kind of wondering what happened after that because apparently it didn't work.
It didn't work, Your Honor. I mean, obviously, I can't discuss settlement discussions, but we tried. And we've tried a number of times to try and resolve it. But absent settlement, what happens? As counsel, we were trying to figure out what the next step is. We don't know, other than if the court says no more, you can't file the note of issue. Okay, so what's the next step? Unless the court's going to dismiss the case.
But at the moment, there is a note of issue filed by Upside, correct?
There is.
Okay.
I understand the issue, but then there's the issue of they filed it after the court order. So is it a valid note of issue? It was filed maybe 100
The order was only directed toward the plaintiff, I think.
Excuse me?
The order that you can't file a note of issue was only directed toward your opponent in the room right now, not against anybody else.
I don't know if it didn't say plaintiff. It just said and I'm sorry, I know I'm out of time, but I do have the court order.
No, we have it too. We'll have a look.
Yes, I don't know if it only says plaintiff, it just says file note of issue on it before.
All right,
Thank you, Your Honor.
Thank you. Hey, counsel.
Counsel claims that his client, the principal of his client, Mr. Sharma, stated that he clarified there's no physical contract. Then it is unclear why he on several occasions during his deposition stated that I have a copy, I can get you a copy. And Mr. Graff mentions that he spoke with his client about the contract, and his client confirmed
Counsel,
there's no
is there
verbal
any
contract.
reason why you didn't subpoena the contract, this potential contract from the other party?
There was no need for a subpoena because we received the Jackson affidavits from his client stating that they performed a full search diligently, and there are no documents relating to the foundation. So for us to send a subpoena, that would be second guessing the Jackson affidavit. That would be, again, going back and wasting time and money when we wanted to proceed with the deposition.
So at this point, with the information that, you know, there's no contract, why not just move forward? And then if a contract appears, then that's kind of sanctionable, right?
We don't want to speculate and wait to see what happens because that could put the case for my client in jeopardy. But going back to, as a rebuttal to Mr. Graff's earlier statement, I do want to clarify that he mentions that his client stated there's no verbal, that the agreement was verbal. Okay, so, if that's the case, he has not clarified about the other foundation related documents such as the requisitions, the applications for payment, the schedule of values. Those are all documents that Mr. Sharma testified to having physical copies of in his cabinet at the Trip Hotel. And there is no mention during his deposition testimony
His deposition was specific to those documents and they being within the file cabinet, or was it generally where he would keep documents if he had them?
it was specifically targeted towards the Sains and foundation-related documents. And there was no mention of the owner's rep having custody of these physical documents. Mr. Sharma stated that he has those documents in his cabinet. It was in his possession. Mr. Sharma's affidavit in July makes no attempt to clarify that earlier statement made during his deposition testimony. And in terms of the offset,
Thank you, counsel. I don't think we have any other questions. Thank you very much. We have your papers. Thank you both. People v. Pichardo.
Good afternoon. I'm Catherine Martone on behalf of Mr. Pichardo. A lesser sentence would be more appropriate in this case.
Do you mind using the microphone?
Sure. A lesser sentence would be more appropriate in this case. On a guilty plea to charges that included the top count of the indictment, criminal sale of a firearm in the first degree, Mr. Pichardo was sentenced to 8 years, followed by 5 years post-release.
Right. The people wanted 10 years, correct?
Yes, yes. The minimum for this offense for a first-time offender, felony offender like Mr. Pichardo, was 5 years.
Yeah, I know that's what you're asking us for, but
Yes.
such a large number of loaded guns, including automatic weapons.
Yes, Judge, the offense is the sale of 10 or more firearms, and this case involved the sale of 16 operable firearms, and there were 2 firearms that were inoperable. But the unusual thing about this case is that there is such significant mitigation. At age 28, at the time of the offense, Mr. Pichardo had only 2 misdemeanor convictions. He, during...
That's mitigation?
That's a, Judge, that's a relatively minor criminal record for Mr. Pichardo at age 28. And the other important thing about taking into account is criminal history and this incident is that during the 2 years, starting with his first misdemeanor conviction and ending with his arrest in this case, he suffered from serious mental illness and addiction that led to 2 suicide attempts during that same
Counsel,
time.
can we go to the waiver issue? Because we kind of didn't even address it, and I think we have to address that first.
Okay, sure, Your Honor. The problem, the reason the waiver is defective in this case is because before the plea court asked Mr. Pichardo anything, the court directed counsel to review the written waiver form with Mr. Pichardo. And counsel advised the court that he did not want to sign it.
This is true, but then he said, he misheard the defendant. And I didn't see anywhere in the transcript where when counsel said that, defense said, no, that's not true. I don't want to sign it. He,
Yeah, what I think is needs to be taken into account as part of this record is that when counsel said that, the plea court immediately said, that's it. And that plainly conveyed that the offer was going to be withdrawn.
Because right after that exchange, the court did ask, did anyone force you to sign? And he said no. And the court, this transcript was very, very detailed. Explained the nature of the right to appeal, explained that the, rights waived was, separate and distinct from, the right to appeal, and even talked about the claims that survived the waiver. So that's the only reason why, is because counsel made that misstatement that you say it's invalid?
Yeah, I don't think that was, I think a fair inference from this record is that counsel said that because the court's statement indicated, okay, that's it. The plea offer is being withdrawn, and that after that, Mr. Pichardo right away signs the waiver. He says yes, yes to everything the court asks him.
Well, I mean, is that really a fair inference? Because if the people are requesting the waiver and he's not pleading to the indictment, which he's not, right?
Well, he's pleading to the top count.
That's not the indictment.
And three other, three
Right.
other charges.
And then there's some that he's not pleading to, so the people still control the plea. So to that extent, when the court says that's it, isn't that indicating, well, we now have a problem because the people are requiring that you waive your right?
Right. And there's no doubt here, Your Honor, that the waiver was a part of this plea bargain. But all I'm saying is that he was entitled to understand just what it was that he was waiving. This was not a defendant who was playing games with the court. He indicated at Supreme Court arraignment, even before there was an offer, that he wanted to plead guilty. He pleaded guilty on the very next court date, even though the offer was open-ended in terms of the court promised only to give him no more than 10 years, with the minimum being 5. So when counsel says he doesn't want to sign it, at a minimum, the court should have asked, why? Maybe he just didn't want to sign something he didn't understand. But we don't know because the court didn't ask, the record is unclear, and the record needs to be clear for this waiver.
What is clear is that the court went on to explain the waiver. So why is the why at that point more crucial than the explanation that comes later?
Yeah, Judge, what I'm saying is that paves over the problem. It's trying to pave over a problem because Mr. Pichardo wanted to plead guilty. That's clear. It was his desire to have this offer. And when the court pulled it off the table, everything he said, I think, does not cure the problem that the court didn't ask him whether it was something that he didn't understand. It was coercive, Judge, is what I'm saying.
Thank you, counsel. You have time in rebuttal as well.
Yes.
Good afternoon, Christopher Marinelli for the people.
Counsel, I'm sorry to just jump in right away, but it's an easy question, right? Why not ask it? What is it? Your attorney's telling me you don't want to sign this. Why is that?
The attorney immediately says, I misheard him. So the court, I think.
Is that what happened? The attorney says, I misheard him after the court's remark, which is open to interpretation, right? That's it. That could be the attorney recognizing that this whole thing is in jeopardy.
I mean, the attorney is telling the court, I made a mistake. I don't think, it's required for the court to jump to conclude.
It may not be required, but I would certainly suggest it's better practice.
It's in the moment. I think, it's a natural reaction to.
Well, that's not what we're evaluating. What we're evaluating is under the circumstances did he knowingly and intelligently waive his right to appeal.
Absolutely. Even if like I said, I don't think we should infer from the record that there was a genuine hesitation on the defendant's part, but then it was.
And the court did go on to ask him about signing the waiver, whether he did so voluntarily, whether he was forced to sign it, and the defendant answered in the negative.
Precisely. It's a very, tracks the colloquy very closely. You do have the written waiver as well. He has assistance of counsel on the totality of the circumstances. I think this is a valid waiver. Even if there were an issue, this is 14 separate sales. The defendant was in his late 20s, so this is not a bad day or a youthful indiscretion. I think the thing about the mitigation here, it sort of cuts both ways. If you have a defendant with these issues, maybe he's somebody who does need to be monitored, because at this point, I believe he's discharged the prison sentence. So I think it's a question now of the length of post-release supervision, and he has struggled in the past. He had another case where first case he was on probation, he violated probation, he took another conviction for drug conviction, he went to treatment, built out a treatment. It seems to me that somebody who perhaps could benefit with some oversight to try to keep him on the straight and narrow. Or doesn't have any other questions, we'd ask that you affirm.
Thank you, counsel.
Thank you.
As to the merits, Your Honor, I would just quickly say that there was an unusual amount of family support in.
Counsel, you just made the argument that, the defendant really, really wanted this plea,
Yes.
right? So it was something he was aware of, he bargained for, and he really wanted it. That was your words. Why now is it excessive, something that he really wanted?
Yeah, it's excessive, Your Honor, because it doesn't give proper consideration to the family support and the mental health issues and addiction that he was struggling with at the time these offenses were committed. His entire criminal history was happening at the time.
Wasn't that before the sentencing judge?
It was, Judge, and what I'm saying here is that this court on appeal does not give deference to the sentencing judge's sentencing determination. And I'm saying this court, considering all of the mitigation, which was really unusual. I mean, the family members were in court on his behalf every time. People put in letters of support for him, even though he suffered from addiction and mental health issues, which are problems that cause people oftentimes to lose their family relationships. His family was right there for him. I mean, he had someone who had been a friend for 20 years putting a letter into the court on his behalf. So I'm saying this sentence of 8 years, where the minimum was 5, and he pleaded guilty to the top count of the indictment, albeit not the entire indictment. He did that early on. He took that plea. I don't think that sentence fairly takes into account his favorable background, and the court should reduce it.
Thank you, counsel. Thank you both. Jean-Louis v. New York City Department of Education.
Okay.
So you are Emmanuel Jean-Louis?
Yes. Good afternoon, everybody. May it please the court, my name is Emmanuel Diane Jean Lewis, and I am currently pro se. So, unfortunately, my respondent hasn't wasn't able to make it, but this appeal is to narrow the questions whether the DOE discontinuance is entitled to the deference when it is stated rational is contradicted by the administrative record. Under the penal law and the Pell, Swatton, and Gross, it shows that the record undermines the agency's explanation. So, therefore, I am asking that the court rule in my favor as far as providing me back my job when it comes to working for the Board of Education. I don't know how often this happens within the system where someone with great work ethic is fired for whistleblowing. And I didn't even know that was a thing, to be honest, because as a mandated reporter, I have 2 licenses under the mental health and also under the school, that it shows that is my job. My job as a mandated reporter is to walk in spaces like these and be able to advocate for, our clients, our victims, and just the community in whole. So with my satisfactory, no disciplinary charges, a full-time position, not just as a guidance counselor, but working in a system for 13 years and nothing under my file until, unfortunately, in 2023, where I was being targeted by Principal Bernard and AP Dorius, and their records are contradicted within their own records, right? They said, Miss Jean Lewis is the 504 coordinator. Then they turned around and said, Miss Jean Lewis is not the 504 coordinator verbally. However, we will find these on the appeal record 32, 33, 332. We will also find it under 89, which shows the hiring, and we will also find it under 186 to 219. All these documentations were provided within the amount of time that we had, and many of their documentations contradicted what they stated in our space. So even one thing as far as the consecutive Fridays, we only had a certain amount of Fridays between the beginning of school in 2023 September until October 15 when the allegations began. It shows that there would not be a number of 3 consecutive Fridays, according to AP Dorius, for me to be said leaving early.
Thank you very much. You pronounce it Jean Lewis?
Yes, Jean
I'm sorry, Ms. Jean Lewis, for mispronouncing your name. Anyway, we have your papers. Thank you very much.
Thank you.
Danielle BJT, Megan and Company. Please.
May it please the court. Your Honor, is Abe Reichert from Katz and Reichert, representing the defendants and the third-party defendant appellates. L&K failed to meet its burden under the motion to re-argue CPLR 2221D. It didn't demonstrate that the court overlooked or misapprehended any law or fact or misapplied controlling principles of law, but most importantly, the cross motion was untimely. It was almost 3 months after the deadline under the CPLR, and more significant than that, it attached different evidence, different information, tender communications.
So it was a cross motion, right?
It was a cross motion, correct.
So they're allowed to also respond to your motion, right? And make
They are permitted to respond.
And that's, of course, what they say about this additional documentation. So is that not correct?
Again, that was a re-argument. It was our motion to re-argue. It was not submitted on the original papers, and this was something that L&K had in its possession from the get-go. It had an opportunity to make those arguments in the original motion, but it didn't. And the requirements of 2221 are very specific in terms of not permitting new arguments or new evidence on a re-argument.
But the requirement is that you show the court how it may have misapprehended some controlling law or some issue in the case, right?
Correct. Right. And we maintained L&K did not do that. They did not properly meet that burden, and there is no argument that the court misapprehended or overlooked anything. The arguments that were made originally spoke about USIS and USIS Inc., spoke about Axis, spoke about the fact that defense and indemnification had been accepted without reservation, and that counsel was in fact assigned. Actually, our firm was assigned to represent them. There was a federal court action where Travelers pursued a claim of coverage regarding the fact that it didn't want to accept that offer of defense and indemnification, and it lost that determination. And then it went ahead afterwards and filed this cross motion for re-argument. But
Now, with respect to the re-argument motion, I know you say that the 3 documents were improperly submitted, but isn't it fair to say that those documents were submitted in opposition to your application?
I think it's whether or not it was submitted in opposition on re-argument. It wasn't. Our position is it wasn't submitted on the original motion.
Because that's
And
what
so
they're
it's
saying.
not permitted. It's not. I mean, we didn't make that argument. We didn't make that argument on re-argument. We didn't talk about. We feel it's a coverage determination in any event. It has nothing to do with liability and nothing to do with contractual indemnity. But we didn't make that argument. They made a combined cross motion, and in their papers, as you can see in the record, they combined both the application for re-argument and similarly in opposition. And in that motion, they stuck these new arguments and these new communications. And you can see from the court's determination, the court is then focusing in the decision on re-argument of, okay, we're talking about USIS Inc.
Just to follow up. You know what? Let me let you finish that sentence because I have a follow-up for you. So
Sure. No, Your Honor, please.
No, finish your sentence.
I think I did finish that
Okay,
sentence.
all right. I just
Go
wanted to
ahead,
make
Your Honor,
sure. I wanted
Thank
to
you,
make
Your
sure.
Honor. Thank you.
So just to follow up on that, did your client object to say, you know what, this submission is improper? Did your client object to the submission of these supposed improper documents?
We did not, Your Honor. We did not on that re-argument, but that doesn't prevent this court from looking at the specific requirements of 2221D, both in terms of timeliness and in terms of new and different arguments from the motion below. But even just talking substantively about what we're talking about here, the court below aptly found that they could not reconcile the offer of defense and indemnification with the claim for contractual indemnity. They had been offered full defense, and yet they're claiming attorney's fees for defense. And I don't know how this court can get past that. I don't know how the judge below could get past that issue, and should have correctly found that the burden was not met on re-argument, and that, as the judge had found originally, it cannot be reconciled. Defense and indemnification was provided. They're claiming attorney's fees for defense. I don't know how you can walk away from defense and then claim attorney's fees for defense. That's what this case involved ab initio in the beginning on the original motion. This argument regarding that the court should reconsider something that was filed in the original appeal should be disregarded by this court. This hypothetical issue of the original order was superseded by the subsequent order, and we maintain that the court below improperly granted the re-argument, should not have considered these new arguments, should not have considered these tender communications. But in the end of the day, substantively, the court committed error because, as it found below, the defense and indemnification was offered, and L&K turned around and refused to accept it.
Thank you, counsel. You have time to rebuttal.
Thank you.
Good afternoon, Your Honor. Jeremy Bernfield for Respondent L&K Partners. May it please the court. Central to all of this is that this matter, this third-party action for contractual indemnification, is between L&K Partners and USIS Inc. Counsel for Appellant has repeatedly discussed defense indemnification has been offered, was offered, passive voice. He's not discussing who actually made what offer. That was an offer by the insurer for USIS Electric Inc. Not the,
Axis doesn't insure USIS Inc., right?
Correct.
It's the insurer for electric only, correct?
Correct.
Okay.
And that's a distinction that Appellant has glossed over throughout this entire appeal. They don't actually even contest that the contract says what it says. They've agreed to it, that USIS Inc. is required to defend and indemnify L&K Partners in this Danielle action. They're talking about what USIS Electric Inc.'s insurer has done, what happened in a declaratory judgment action between Travelers Insurance and Axis, which are not parties to this case. This is just a matter of L&K and USIS Inc. And if there are no further questions, I rest on my papers.
Thank you, counsel.
Thank you.
Just to address that issue, Axis was the insurer or is the insurer for USIS Electric, but USIS Inc. is an additional insured on Axis's policy. And so the defense was offered for both USIS Inc. and USIS, and there's no issue about that. That defense was offered, the defense was, and they walked away from
Indemnity
it.
provision, counsel, it is extremely broad, it seems to me, in arising out of indemnity provision with no negligence trigger. You'd concede that, right?
We do, Your Honor, and it was offered, and it was refused by L&K for some reason that is unknown to us. Why did they walk away from defense, yet claiming that they want attorney's fees? There was no conflict. It was found in federal court action. There's no basis for it. As the court correctly, aptly found below, these two cannot be reconciled. Defense and indemnification was offered. They're talking about another entity. That entity had coverage. The coverage was in place. And they never, by the way, they never pursued Star Insurance. We're talking about that. That's the excess insurer.
So is the import of your argument that if you get insurance coverage that you can never move for indemnification from contractual indemnification? Is that what you're saying?
No, what I'm saying,
there are cases that say that you can do both at the same time, right?
you can, sure, certainly, but you're claiming attorney's fees. That's what they want, attorney's fees for defense, and the defense was offered. And they walked away from it.
Anything else you'd like to add? All right, thank you both. Silverman v. Pretto Manger.
Good afternoon, Your Honors, and may it please the court. My name is Glenn Grinlinger, and we represent Pretto Manger and Catherine Lopez. The claims raised by the trustee in this action are time-barred. There is no dispute about that. The only way they are not time-barred is if the trustee can invoke Section 205A of the CPLR. However, in Ace Securities in 2022, the Court of Appeals specifically said that that 205A can only be used explicitly and exclusively by the plaintiff in the prior action, or if the plaintiff dies and the cause of action survives, the plaintiff's executor or administrator. No one else can do that. The trustee is neither the plaintiff in the prior action, nor is the trustee the plaintiff's administrator or executor.
What did the court say about trustees appointed pursuant to federal law? Was there any explicit language in the decision about that?
The court said that it was not making any, it was not ruling on the propriety of such decisions one way or the other. But the logic of Ace Securities is very clear. It says that that provision must be strictly construed. And strictly construed means it doesn't apply to trustees. It doesn't apply to bankruptcy trustees, doesn't apply to guardians ad litem, doesn't apply to anyone else.
And to be clear, this trustee here was appointed pursuant to federal law, right?
It was appointed pursuant to in bankruptcy court. That is correct. Yes.
And doesn't a trustee in bankruptcy stand in the shoes of the plaintiff here?
The bankruptcy trustee is what we would call a successor in interest. I absolutely concede that. But a successor in interest is not what 205A says. 205A talks about the plaintiff and only the plaintiff, and if the plaintiff dies, the administrator or executor. That is different than 205B. 205B specifically talks about successors of interest in that if the plaintiff or a successor in interest files a new action, based on the same events.
Counsel, are you collaterally estopped from making this argument based on a prior court's ruling?
Absolutely not, Your Honor. The collateral estoppel argument is frankly a red herring. There was no opportunity to address the issues in the prior action under to
Didn't you
argue
move to
2.5a.
counsel, wasn't it live before Justice Hummel because you did move to dismiss the prior action with prejudice, and then she said, no, I'm dismissing without prejudice. So how is that not necessarily decided in the previous action?
Very simply, because the events that upon which 205A on which to invoke 205A had not occurred yet. That court did not have this court's opinion in Messer versus Hughes, where that specific issue was argued, and this court said the issue of 205A is premature and needs to be litigated later. And that's exactly what happened. And I will save my remaining arguments for rebuttal.
Thank you, counsel.
Good afternoon. My name is Avi Mermelstein of Arrington, Dittmar, and Carbon for respondent. May it please the court. Defendant's position stands against the basic principle that a party is entitled to one fair hearing of a case or legal issue on the merits. Defendants seek a second hearing on the issue of whether CPLR 205A is available to the trustee, even though that issue was already decided in a prior case between the parties by Justice Hummel. At the same time, defendants seek to deny the trustee even one fair hearing of a serious discrimination case on the merits. This fundamentally unfair position was correctly rejected by the court below, and we respectfully submit that this court should affirm. First, as defendants are collaterally estopped from arguing the availability of CPLR 205 to the trustee because that issue, as the court noted, was before Justice Hummel because defendants raised it by moving to dismiss the claims with prejudice. Now, we demonstrated on page 11 of our brief that by moving to dismiss with prejudice, defendants necessarily put the availability of 205 before the court. They have not addressed or countered the precedent we cited in support of that point, including this court's decision in Rivera, where the court modified the lower court's dismissal with prejudice to a dismissal without prejudice to allow a future refiling under 205. Now, defendants have raised this court's decision in Messer versus Hughes, but as we noted in footnote 3 of our brief, this case is distinguishable from that one because the argument regarding the bankruptcy trustee's ability to recommence suit under CPLR 205A were the motion court there had just not ruled on that issue whatsoever. Whereas here, it was actually in the decretal that it was ordered that the trustee would be able to recommence suit under 205A. It was argued by defendants in their papers on reply. That's in the record 244 through 46. Also at oral argument, which is in the record 228 through 29. So they had a chance to make those arguments. Those arguments failed, and then they failed to appeal. Does the court have any questions, or should I rest on my papers?
Thank you, counsel.
To address, thank you, Your Honor. To address the collateral estoppel issue in further detail, first of all, Justices Hummel's, language on collateral estoppel is pure dicta from that decision. That decision rested on whether there was a viable action due to the plaintiff's lack of capacity. And if there was a viable action, whether the trustee could substitute. That's all that was needed to be decided in that action. And Justice Hummel said no, there was no viable action, and the trustee's substitution could not correct that problem.
She could have agreed with you though and said, I'm dismissing this case with prejudice, right? She could have done that.
She could have, and she dismissed it without prejudice, but she didn't say that the trustee had leave to refile under 205A. She said it could be refiled under 205A, just like any action dismissed without prejudice could be refiled under 205A, assuming that all the criteria necessary for 205A are satisfied. For example, if the trustee had refiled an action and inserted something that was based on a new transaction, that's not going to meet the requirements of 205A. We wouldn't be collaterally estopped from arguing that that the trustee's new action is barred, is not barred simply because Justice Hummel said that it could be filed under 205A. And I do want to make clear that Justice Hummel does say very specifically that she doesn't say that the trustee can refile the action. She says it can be refiled. That's significant. She could have said the trustee can refile the action on 205A. Presumably, she might have meant the plaintiff, who at that time was still Ms. Watts. And I see I'm out of time, so unless there are any other questions, I would like to thank your honors.
Thank you, counsel. Thank you both. Gordon v. 476 Broadway. Please.
May it please the court, Ian Brandt of Lasser Law Group for Appellant Anthony Gordon. Your honors, this case is the culmination after a final order of over a dozen years of litigation concerning water leaks into my client's co-op apartment that started actually around the time that they purchased it in 2000. But with respect to the claims here, the leaks that started in 2006 and continued at least through 2015. And my client, after suffering a Pullman loss to this court in 2000, there was an appeal.
We're very familiar with the long procedural saga, and I
So
commiserate with you and your client and with the other side as well. But let's get to the meat of the subject.
Right, counsel, the heart of this case was about possession of the condo, the co-op, right?
No, the heart of the case was about leaks. And one of the remedies that the co-op tried to use to, in its mind, after 6 years of not figuring out what was causing the water infiltration to the apartment, they served a notice to cure in May of 2012 saying, you got to give us access. And if you don't give us access within 2 weeks to do water testing to remove the finishes on over 100
So
feet of
what
wall.
I was actually getting at was how are we deciding who the prevailing party is here?
Great question,
right?
Judge. So the prevailing party, I think the standard under Nestor versus McDowell, which is what Justice James cited in her, what I believe to be firmly her premature decision in deeming prevailing party to the co-op against the Gordons in 2018, well before any adjudication actually occurred as to what caused the leaks, whether the Gordons were entitled to damages, and whether the co-op breached the lease prevailing, allowing my client to claim prevailing party status under paragraph 28 of the lease in RPL 234. So
like his first three, the Gordon's first three causes of action all concerned the shareholder vote to remove them, and they did have to move out in 2017.
Correct.
So doesn't that give primacy to possession? And that's the main issue in the case is possession of this apartment. And so therefore, since they won that, don't they get attorney's fees for that?
the Pullman notice, the notice to cure was predicated on let us in to test after 6 years of not being able to figure out what to do. We're going to try new water testing. My client started the action to enjoin the Pullman conduct, but anyone who has suffered any water casualty after 6 years of not having any remedy would say, is this correct? Is what they're doing now correct? They're going to destroy my apartment? Now, the Pullman issue has been decided. Collateral estoppel, res judicata. I'm not here to argue that.
You're saying the Pullman issue wouldn't even have come up if there hadn't been the leak problem and the fighting about the leak problem.
Correct, Judge. That's exactly right. And look, the cases in 2024, this court said in a complex case where a co-op has 2024 decision, a complex case where a co-op has claims for non-payment or maintenance, and the shareholder has claims for property damage, you have to wait to the end of the litigation to make that determination.
What's
not-
still open-ended in the litigation that we should wait for to see who the prevailing party is?
So nothing really. We're seeking remand on certain issues because of the mistake in 2018 where Justice James, perhaps inadvertently, but certainly killed the negligence claim by deeming it a contract claim at oral argument, where she was severing the Pullman decision, severing the Pullman issues after the appeals had all occurred, and said, okay, now you guys are going to adjudicate the property damage case, which was tried in 2021. So this is an appeal. While it's an appeal from a final order, it is in substance an appeal from a final judgment. The final order.
So if we don't agree with you on your appeal relating to the negligence claim, then what is actually left to do in the case?
We believe that the prevailing party decision under CPLR 5501, the statute allows the court to bring up for review that early determination from July 2018 where Justice James deemed the co-op prematurely prevailing party. We believe this should really be a mixed bag case because my client prevailed at trial after full fact-finding. Judge Marin, who was the JHO assigned by Justice James to hear and report back to her, found that the co-op had breached the warranty of habitability for 11 years and granted a rent abatement. The only adjudication in this whole morass of a case is that these leaks occurred. And
But your client didn't get 100% of rent abatement, correct?
my client, well, that's up on appeal too, Your Honor, but yes, Justice Marin basically said you get close to 50%. I think it was 46.5%. But the calculations were done based on testimony from my client personally, the one expert that he was allowed to have at the hearing, even though we had an order from Justice James in 2020 allowing us to have other witnesses who were professional, not expert witnesses, but fact witnesses, the professionals on the ground. I wanted to testify to show the severity and duration of the breach was much less than a 46% rent abatement. Judge Marin said this is a warranty case. I just want to hear X, Y, and Z. He limited the scope. We believe that is something that was reversible error, both on the mold reports and those fact witnesses who are professionals, engineers, and contractors to show the full duration. It's because this was a real mess for years. There's no dispute that. And despite the fact that the co-op blamed my client from the get-go for all of these leaks due to something that was mysteriously called the brown coat and window damage. At trial, it was revealed they had no defense. There was no brown coat problem that my client caused when they did renovations, because this was a gut renovation that started in 2000, and there was no window damage. Mr. Wolf, who was my client's expert, testified at the hearing that the windows were serviceable. They were in good order. The windows didn't cause the leaks. The brown coats didn't cause the leaks. The envelope was failing for years. They couldn't figure out what to do. And at the end of the day, in 2015, they finally replaced the roof. The vice president of the co-op testified on my examination that the leak stopped after they finally replaced the roof. Notwithstanding that counsel came to this court on the Pullman appeal. Again, I'm not here to re-argue the Pullman appeal as much as I'd love to. But counsel came to this court in 2014, and when asked by the presiding judge on that 2014 or 15 appeal, have the leak stopped, Mr. Berkey said, yeah, they stopped. But they didn't stop.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. Michelle Quinn for the respondent, defendant, 476 Broadway Realty Corp., the cooperative. May it please the court, Your Honor is correct. This is an eviction case. The claims about damages are ancillary. Anything about the leaks are ancillary to the pure fact that this was about access and other.
It started off as an eviction case?
It started out.
Started off as a leak case.
It actually did start out as an eviction case. There was a case brought in housing court, which was discontinued based on other conduct that was engaged in by the defendant, by the Gordons, which then led to the notice of objectionable conduct, which included not just getting access for the leaks, but interference with workmen, leaving belongings in the hallways, other conduct not just related to the leak issue. So the Pullman.
So why isn't this a breach of habitability case instead, based on the leaks?
So the Gordons brought the case as a reaction to the Pullman, and only after the shareholders had already determined that they should be evicted. And yes, the breach of warranty of habitability is a portion of it, But as Your Honor recognized, they looked for 100% abatement, but they were not awarded that. In fact, they lived in the apartment, which means it cannot have been 100% uninhabitable. So they were not entitled to a 100% abatement. They received a 46% abatement. In fact, they did not give access for 7 months during the time that the cooperative was trying to remedy the repairs that they were seeking. So as Your Honor recognizes too, this is about eviction, which means that the cooperative is the prevailing party. There's no degree of success with an eviction. You either are or you're not evicted. So the Gordons were evicted, meaning the cooperative is the prevailing party. With respect to the negligence claim or the alleged negligence claim, it's not pleaded in the complaint. Judge James, when she reviewed which appellant was present for the oral argument during which Judge James reviewed the amended complaint, he was present for it. He heard her decision that stated that the purported negligence claim was duplicative of the breach of contract claim, and he did nothing after that. He's a sophisticated litigant. He could have moved to re-argue. He could have asked for clarification. He could have filed an appeal at that time. He could have done any number of things. He could have moved to amend his complaint. He had an attorney previously. He had an attorney subsequently. He even later recognized his mistake in 2020 when he did try to go back and fix it. He's not a stranger to litigation. He appealed the 2014 Pullman decision. So he could have appealed the dismissal, not really dismissal, because in fact it wasn't a dismissal, Judge James' decision to stating that it was a duplicative claim, but instead he chose to litigate for 7 years and engage in the litigation, go to 5 days of trial.
Given that given that the other side were awarded 46%, why isn't this a mixed win?
Because you have to look at the substantial results. The mixed bag, I believe I'm gonna look at where neither party achieves substantially favorable results. Neither party. The cooperative's claim was for eviction. That is substantially favorable. It's in everything they were looking for. So they are the prevailing party. Even if you were to balance that with the warranty of habitability claim, the Gordons only got 46%. That's still not substantially favorable. It's less than 50%. And it was partly due to their own conduct.
Substantially favorable is a mathematical formula?
So the cases that are relied upon by the appellant discuss a monetary balancing. So the mixed bag results that those are deal with a monetary claim by both sides, and that is a balancing. And yes, maybe in those cases where both sides are looking for money, you look at the outcome and you say it's a mixed bag result. But the cooperative wasn't looking for money. The cooperative sought their eviction and obtained their eviction. If there's no other questions. Thank you.
Your Honor pointed out one of the important things here. If law were an algorithm, we would be doing something different, but it's not. So the standard really is, the court is supposed to consider the initial consideration of the true scope of the disputed litigated issues and what was achieved. They got their Pullman win without any judicial review, because that's unfortunately the law in the state of New York. This wouldn't have happened to any other type of residential tenancy. Whether it's a rent-stabilized apartment or a fancy luxury apartment, there's no Pullman determination. If a landlord says that a tenant is a nuisance or objectionable, that needs to be litigated by competent evidence of a court. That's what RPL 711 says, or RPAPL 711 says. So look, there's a judicial determination in the state of New York that in a co-op, you don't get judicial review when you're accused of objectionable conduct. But here, my client's not a Pullman. It's a traditional Pullman guy who did something terrible, who took baseball bats to pipe, like in the Whitesnare case, or like David Pullman, who did things that I really don't want to say in the courtroom. They were being inundated by floods for years. And in a 2-week period, they questioned whether a co-op should come in and spray test and oust them from apartment. And by the way, the standard of the warranty of habitability is not abandonment. That was adjudicated at trial. They're relitigating something they shouldn't be saying to this court. You don't need to abandon your apartment to get 100% habitability abatement. You could live in the apartment. I mean, the Granier case versus the bakery is case in point. That's the case, I think, from 2008 that this court awarded 100% abatement in a co-op apartment, including abatement of an assessment, which is what we're seeking here on review. We think the trial court, the JHO at the habitability hearing should have awarded that as well, including prejudgment interest. But where to begin with? I mean, some of the issues that are being raised. I mean, it's that there's so many of them that council's bringing up that should be refuted. I mean, the habitability issue, 46%, that's substantial abatement over an 11-year period. And I think it's clear to the court that, the gravamen of this matter was leaks that wouldn't stop. Part of the issue resulted in a Pullman termination that was fully adjudicated, but there was no fact-finding there, and the fact-finding in 2021 revealed that these were substantial leaks that caused my client to lose an apartment. And it's a mixed bag. It really is.
You do make that point fulsomely in your brief. Thank you both.
Thank you, Judge.
People v. Alkim Phillips. Please.
Good afternoon, Your Honors. May it please the Court, Legal Aid Society by Hannah Gladstein for Mr. Phillips. In our brief, we raised 2 points that are really closely related because they both arise from the only contested issue at this trial, which was whether Mr. Phillips had the intent to permanently deprive the complainant of his envelope when Mr. Phillips picked it up off the ground after punching the complainant, abandoned it seconds later, then returned to talk to the complainant before walking off again and remaining outside the subway station. I want to start with the weight and sufficiency of the evidence, but I do want to make sure that we save time to get to the jury instruction. If the prosecution had charged Mr. Phillips with assault, this would have been a very straightforward case and we probably wouldn't be standing here now. But they chose instead to charge Mr. Phillips with a robbery, and in doing so, they assumed a burden of proving beyond a reasonable doubt that Mr. Phillips had the intent to permanently deprive the complainant of that envelope when he took it.
Why couldn't the jury draw that inference, counsel? If there'd been money in the envelope, for example, and they'd taken the money, that we wouldn't be here today arguing this point. But he took something from the defendant after cold cocking him and knocking him to the ground, breaking his glasses. What's he going to do with it? He's just taking the thing to throw it on the subway stairs later? I mean, what's he going to do? Why isn't it a reasonable inference?
Well, we don't know. The problem is that they have to prove that, and we don't know. And what the prosecution has offered as reasonable inferences, I mean, it would be generous to call this case circumstantial. It really is just speculative.
Counsel, what we do have is he punched the witness in the face.
Yes.
Envelope dropped, and he took it.
He punched the witness.
So what the jury's to look at and what we're to look at was what was his intent at that moment, correct?
Yes, and
so it's possible that he had the intent to permanently deprive the victim of his property, and then he looked inside and said, I don't really like this, and chucked it.
Well, Your Honor,
that doesn't change the intent.
Possible is not proof beyond a reasonable doubt.
Well, it's all by inference. So why couldn't the jury infer this?
Well, there are equally reasonable inferences, and that is not proof beyond a reasonable doubt. So
how is it equally reasonable that you punch someone in the face, take their property because you intended to temporarily possess it?
Well, we have to look at the entire circumstances here. But
you also have to apply some common sense, right?
Well, sure, but let's look at the entire circumstances, which is that there's no evidence, first of all, that he ever examined the contents of the envelope. That is entirely speculative. So what we have is he picked it up, he drops it seconds later, he doesn't leave. Like, if he was trying to steal that envelope...
He came back, counsel, to sort of coax the witness into saying that it wasn't him.
Well, but he did that by trying to blame it on somebody who the witness was never going to believe was the actual assailant.
Right, which is incredible in and of itself.
I think that what the prosecution does here, and what I don't want us to do, is try to impose a coherent narrative on something that just is not coherent. Like, no step of this makes sense. And to try to impose sense on it is to...
It's not imposing sense, it's drawing reasonable inferences from what's in the record and from what evidence is present.
Well, so there's no, first of all, there's no evidence that Mr. Phillips saw the complainant and saw the envelope before going up to him.
Well, there's evidence that he took it, right? So what's the reasonable inference after you punch someone and you take whatever they have and leave the scene?
Well, I think if we zoom in on that alone without looking at the entire circumstances, then really any taking is a larceny, and that's not what the law is. I see that my light is on. I would like to talk about the jury instruction while I have some time.
So the court pretty much tracked the standard CJI language. And I know that trial counsel asked for additional language from, I forget the name of the case, but Fox, was that the? Anyway, he asked for additional language. Wouldn't that language have been redundant?
Well, no, I think the court's instruction and the court's use of the CJI is what was redundant here. The defense proposed an instruction that just cut to the heart of the matter. It told the jury, you must find, I want to read it verbatim.
We already saw it. You don't have to really read it.
The defense instruction was straight to the point. What the court did, and yes, the court's language was drawn from the CJI, but that's not dispositive. From Walker, we know that if the CJI risks confusing the jury, then that's reversible error. The defense's position was buried in this paragraph of generic boilerplate language that had no application to the facts of the case. The defense
And was that confusing? Was there a risk of confusion there?
Well, we see that there was confusion because the jury came back with several notes asking for re-instruction. And it really...
Is asking for notes and re-instruction equate undoubtedly to confusion?
Well, the case law says, People v. Telesford, People versus Medina say that when a jury asks multiple times for re-instruction on the same point, it's a reasonable inference that the jury was confused. And here, where there was really only one thing that the jury had to decide in this case, it is a reasonable inference that that one issue is the thing that they were trying to understand. So this was not a harmless error because we see in the jury's deliberation that they were really struggling. And the defense was entitled to an instruction that applied the law to the facts of the case, that was tailored to the facts of the case, and that did not risk confusing the jury. And the defense put forward an instruction that did that. The court acknowledged that that instruction was legally sound. The court said, there's not a problem with this. I just don't have to do it, and so I'm not going to do it. I'm going to use the CJI instead. But what the court did was cobble together pieces of the CJI. The court was trying to address this issue that the court identified, which is that the case law says, when requested, you must give the statutory definitions of deprive and appropriate. But the CJI says use the petty larceny expanded instruction. So what the court did was do both. And so you ended up with all of this. You have the definition of deprive, the definition of appropriate, and then this long paragraph on page 300 of the transcript that is from the CJI, but is just more generic verbiage covering circumstances that just aren't present in this case. Whereas what the defense did was have the statutory definition of intent of deprive, appropriate, and then this clear distillation of how all of this applied to the facts of the case. And
Thank you,
had the
counsel. You
jury
have time in
heard that-
rebuttal as well. Thank you.
Thank you.
You've gone over quite a lot.
Good afternoon, and may it please the court, Faith Petrolio for the people. Defendant's conviction should be affirmed because the people presented evidence beyond a reasonable doubt that defendant was guilty of second-degree robbery. The video evidence and the victim's testimony confirmed that defendant approached the victim, saw the envelope in his hand as he approached him from the right-hand side at the turnstile as the victim was swiping his Metro card. The defendant then punched.
So the CJI instruction.
Yes.
Sorry to just jump to that. Does it include any discussion about temporary possession?
Yes, Your Honor. The court's instruction track the CJI, which explicitly lays out that although the intent has to be for a permanent deprivation, the taking itself can be temporary, and that is made very clear in the CJI, and the court gave that instruction to the jury.
Do people object to defense counsel's suggestion for jury instruction with regards to temporary use, temporary possession?
I'm sorry, can you?
Do you object to their request to use their version of jury instruction?
Oh, I think that we joined counsel's request for the expanded instruction on intent and intent to permanently deprive as found in the CJI.
As found in the CJI, but with regards to the instruction that they, I'm going to say wrote, that they put together, did you object to that?
Not from my memory, Your Honor. I don't believe we had commented on the record about our position on their specific instruction. But there was a very lengthy, discussion with all of the parties across many days over what was going to be in those instructions given to the jury. And like I said, the intent and intent to permanently deprive instruction was the expanded version was given of those. The appropriate and deprive language was given at counsel's request. And so overall,
You agree that the jury here did struggle with this point, right? And I mean, in fact, I think one of their requests was to have the law to have it written, right? A copy of it.
yes, Your Honor, they did ask to be reinstructed multiple times. I wouldn't say that necessarily they were confused about one certain thing or that counsel's
I don't know that
instruction.
confuses the right words, but they were definitely focused.
They definitely were focused, but I don't think that would show that counsel's instruction would have provided more clarity. In fact, because the instruction was already quite lengthy, I think any additional information, any additional language that was presented could risk actually confusing them, especially in this case when the additional instruction didn't provide any more substantive information that was already in the jury instruction that was given to the jury. There are no further questions. Thank you.
Thank you, counsel.
Okay, a couple of points.
Counselor, just to clarify, because I'm having a memory failure, my apologies. Your request for the instruction, was that the original instruction to the jury, or was that the subsequent instruction once they came back with the notes?
It was the original. So there was, as counsel said, there was lengthy discussion. The prosecution did not object to, the prosecution really didn't participate in this conversation at all. It was between the court and defense counsel. The prosecution did agree that the case law required the statutory definitions of deprive and appropriate, but then didn't provide any objection or feedback to the defense's additional requested instruction. As to whether the court's instruction, the court's instruction contains the word permanent, but it's our position that that's not sufficient. And in fact, when you look at the last paragraph of the court's charge, which again is from the CJI, but it is like a very crystal clear distillation of the prosecution's case. The crime of larceny is complete when a person has the intent to deprive or appropriate permanently, and that person wrongfully takes the property for any period of time, however temporary. The defense did not get a similarly clear distillation of their case. What they get is this paragraph on page 300, which is like aiding a third person to exercise control over it permanently or disposing for a third person. It's entirely generic. The language is in there, but not in a way that the jury was readily going to understand, and we see that they did not readily understand it. And finally, as to the prosecution's position that, somehow the defense instruction would have further confused things, in fact, the defense instruction was shorter than what the court said. So it would not have been more confusing or inject more length into the instruction. It's not that it was adding any additional substance, as my adversary just said. It said it in a more concise and clear way that the jury would have been more likely to understand.
Thank you, counsel. Thank you both.
Thank you.